Is Pennsylvania actually on the road to repealing its controversial and pernicious filial responsibility law? And more importantly, if you don't live in the state of Pennsylvania, why should you care and be interested? And you should. The details come after the introduction. This video comes about as a result of the state of Pennsylvania actually taking some action in order to change its controversial and pernicious filial responsibility laws. And even if you don't live in the state of Pennsylvania, you should watch carefully what happens with this law because it does affect potentially policies within other states. In order to give you a complete picture of what's happening, I'm going to do the following things. First of all, I'm going to explain what filial responsibility is. Secondly, I'm going to describe why it is a concern to everyone that has an estate plan and why you should be concerned, even if it's not the law in your particular state. Third, I'm going to describe the evolution of filial responsibility laws from the federal government to particularly Pennsylvania and how that law has been implemented. And fourth, I'm going to discuss specifically what Pennsylvania is actually doing. So let's begin with what filial responsibility is. The most important thing to remember about filial responsibility is that it is a law whereby children can be made responsible for providing support, either physical support or financial support for their indigent parents. That law would require a child who is capable of paying for the long-term care for a parent. Now, why this should be a concern for you, whether you're a parent or a child, is that these types of laws threaten our estate plans. And let me explain some of the reasons why. So let's say that you're a parent and you have planned your estate accordingly, and you have an objective or a goal that you don't want your children to be responsible for your physical or financial care. That is a very common objective. I can't tell you how many clients tell me that they don't want to be a burden upon their children. Well, even if you do sophisticated planning, do an excellent job of putting together your financial plan and your legal plan, this law would make your children responsible in the worst case where you are unable to pay for and care for yourself. The burden is shifted not because of your plan or your objective, but legally because of a law of the particular state. Let's say that you're a child of older parents, and your primary objective is to take care of your spouse and your children, and you don't want anything to interfere with that. While you would probably do all of the ethical things that are necessary to care for your parents, you don't want them to be a burden upon your obligation to care for your children. And again, if that is your objective, despite your planning and despite any effort you might even be making with regard to your parents to provide for good care and to provide for financial stability, that you could be made to bear the burden of your parents' long-term care, compromising your objective of taking care of your children. The other reason, then, and I'll give you the reason that this becomes important to me as an estate planner, is that filial responsibility threatens the vast majority of plans out there that you might call a Medicaid plan. So what is a Medicaid plan first, and how is that compromised by filial responsibility? Well, you probably understand how Medicaid works. Medicaid for seniors works this way. When you run out of assets and you need care in an institution such as a nursing home or an assisted living facility, Medicaid will come and pay for that care. So if you are a senior and you have to go into a nursing home or an assisted living facility, well, Medicare is not going to help. And you are going to have to spend down your assets to provide for your own care. That's why so many seniors plan by making sure that they've got good, sound financial plans. They may purchase assisted living insurance. They may purchase nursing home insurance or long-term care insurance. They may purchase insurance in order to provide for care in their own home health care insurance. They may employ disability insurances and also what I would call catastrophic illness insurance, like the typical cancer policy, which, if you have a catastrophic illness or a catastrophic event, you simply get paid a benefit. All of these can provide a rubric of a safety net for a senior to try to blunt the cost of long-term care. But it is undeniably expensive. And so many seniors find themselves in a position where they spend down and have to run out of money because of the cost of that care. Medicaid plans are designed to protect assets in advance by removing those assets from the countable assets of the Medicaid estate. In other words, the assets that Medicaid actually looks to in order to determine your eligibility for Medicaid. The most common type of plan is to create an irrevocable trust, which you then put your home or your farm or your assets, your personal business assets, if you have a small business, into the irrevocable trust. And of course, you must do that with 5 years in advance of any type of need because there's a 5-year look back. And then that trust then protects those assets from being countable in determining your Medicaid eligibility. You've effectively protected those assets. The problem with filial responsibility is that filial responsibility is not something that is necessarily just enforced during the life of a parent. So if the state has filial responsibility, what can happen is that after the parent dies, as part of Medicaid resource recovery, the state can look to the children for reimbursement of what the state is paid for in terms of care. Now, how does that affect your Medicaid plan? Well, if your Medicaid plan resolves all of the assets of the estate of the parent's estate into the children's estate, we've jumped from the frying pan into the fryer. In a filial responsibility state, there is always the possibility that the state may just simply collect those assets after the death of the senior by simply asking the children to pay what was their duty to provide for their indigent parent. Hopefully you can see how this can frustrate a Medicaid plan. You can have spent a tremendous amount of money and time and taken what I consider to be extraordinary risks with that type of plan, only to find that the plan has been undone by what the state has determined because of its state law. If filial responsibility is the law in that particular state. Now, I want to talk about, before we talk about what happens with Pennsylvania specifically, I want to talk about how filial responsibility has been reintroduced into the United States. In fact, I read a recent article by a law professor. I'm going to include that article, by the way, in the written materials that accompany this video. And she had a very interesting take on the Pennsylvania law. She wrote, and I want to quote her specifically, that Pennsylvania is one of the few U.S. states that still has an active filial support law that can sometimes be used to compel adult children to care for and maintain or financially assist an indigent parent. And then she, of course, cites the Pennsylvania statute. She then makes a historical connection that I had never ever made with regard to this type of law. She says the Pennsylvania legislature raised the profile of a somewhat dormant but long-standing colonial era statute by moving it from welfare laws into the domestic relations law in 2005. Now, just to explain what that means, what she's saying is that in the colonial era, before we had a government safety net, before we had systems like Medicare or Medicaid, the people were required to take care of each other. And so in the colonial era, it was the law that a child would have to take care of an indigent parent. And of course, that was the reality of our familial social structure back in the colonial era. As the state grew in its willingness and its ability to provide for and be responsible for its citizens, that they took more and more of that obligation. And our world just moved away from the old concept of everyone in a family taking care of and being responsible for each other. Now, whether or not that should be the case, that's what happened. Filial responsibility laws, as they're being applied by states today, are not the product of parochial concerns regarding vulnerable citizens. Filial responsibility laws, especially those laws that came into place in the 2000s in states like Pennsylvania's filial responsibility laws, were not born of the parochial concerns of a legislature with regards to its citizens. They were products of the federal government. You see, back in the late 1990s, and I will put a link to this policy paper so you can actually see it, the United States federal government, through CMS, CMS is the agency that actually governs Medicare and Medicaid, had a great and grand idea. You see, one of the concerns with Medicare and Medicaid is the cost of care, the cost of administering this extremely expensive benefit. And if you have seen an aging in place seminar, you know that some of the problems with Medicare as regards long-term care is that the government has made decisions on the basis of cost that don't necessarily equate to quality care. Well, CMS was involved in this whole cost containment juggernaut in the 1980s and 1990s, actually at the same time that they were moving people quicker and sicker out of hospitals and into nursing homes. But one of the grand ideas was that, well, you states, you could be a big help in providing for the solvency and financial integrity of the Medicare and Medicaid system if you would just go back to laws, filial responsibility laws, where children bore the financial responsibility of providing for their parents. And that would allow you to recover resources that currently you're not recovering. And that then will keep the costs of Medicare and Medicaid down. Of course, that paper is a pure financial paper. It doesn't talk about the social consequences. It doesn't talk about the fact that when a parent becomes a burden on a younger family, what that means with regard to the inability of that family to take care of a spouse, or the inability of that family to take care of children, and how misery can actually be the consequence. It didn't consider any of those things. And so as a result of that paper, some states took the bait, so to speak, and implemented filial responsibility so that the state could basically begin what I would consider the grand experiment. Can filial responsibility save the state and federal governments significant amounts in their Medicare and Medicaid costs? So let's talk about the development of this law in the state of Pennsylvania so that you can understand why I say that the law is both controversial and pernicious. Most of the modern Pennsylvania disputes, the cases, and by the way, most of these cases, the cases that I'm going to specifically talk about, I've written articles about on my aging in place planning and elder law blog, and I'll include the links to those articles in the written materials. Most of the modern Pennsylvania disputes from approximately 1995 to the present have been in the context of costs for care for a parent in a nursing home, where the parent has been found to be ineligible for Medicaid benefits for long-term care. Now, the most compelling cases for such a result where a parent was found to be ineligible for Medicaid was where the targeted adult child has misused the parent's financial resources. So some of the cases involved folks, children who mismanaged their assets or actually stole from their parents, and filial responsibility law was used to go after those particular children. For example, in one well-known case, the adult daughter actually used a power of attorney to admit her mother to a nursing home at the same time that she was gifting herself over $100,000 from her mother's bank accounts. That gift triggered her ineligibility because it was considered to be an improper transfer. That case is known as the Bud case. And again, I wrote an article about that particular situation. But there's a whole second class of cases in the state of Pennsylvania where was no wrongdoing on the part of a child. A child was just being asked to bear the responsibility of the child's parents' long-term care costs. For example, in 2012, an adult son was found liable for his mother's nursing home care, but without any allegation that he was engaged in self-dealing or deceptive behavior towards the nursing home. That's called the Pittis case. And again, I've written an article about that particular case. So just so you understand what happens from a practical standpoint is that a parent applies for Medicaid. They are determined eligible for Medicaid because there are no assets. But then the state of Pennsylvania knocks on the door of a child and says, you're responsible for this care. And with assets being available through the child, then Medicaid is no longer responsible for providing for that adult parent's care. This application of the law became increasingly controversial because of its effect, what I would call the descent of misery in the state of Pennsylvania because of this law. So the first thing that happened is the state of Pennsylvania took the position that the responsibility of children to provide for a parent is what's called joint and several liability. It's a liability that all of them are responsible for, but any one of the children could be held responsible by a party that wanted to hold that party responsible. We see joint and several liability all the time in creditor-debtor relations. So the state of Pennsylvania wouldn't sue every child and ask for every child to be responsible because every child's probably not able to be responsible. So what would happen is that Pennsylvania would pick the child that had the most resources, and the state of Pennsylvania would go knock on that child's door and ask that that child be responsible. Of course, that child doesn't feel that that's very fair. And so as a result, the next phase of the evolution of the descent into misery was that that child would sue his or her siblings. And that created a whole level, another level of litigation and court cases. So the state of Pennsylvania, in its infinite wisdom, decided, well, this is not working out so well. We don't really like all of these children suing each other. So rather than change the law, the state of Pennsylvania eliminated the right of a child to sue another child for indemnity or contribution. That's the legal term for a lawsuit that one child would file against another child when they have joint and several liability. So Unlike other joint and several liabilities, the state of Pennsylvania actually carved out an exception in their law so that one child couldn't sue another child when one child was being asked by the state of Pennsylvania to pay the whole cost of his or her parents' nursing home care. Sounds really fair, right? And you would think that that would be the end of the situation because, and I'm sure Pennsylvania thought, well, we've solved that problem. But of course, that didn't solve any problem. What happened next was that smart children, especially children that were wealthy and had resources and means, learned about what Pennsylvania was doing, and they began implementing their own plan. So this is what happened in those situations. You're a son, for example, or a daughter that owns his or her own business, and you know that if the state of Pennsylvania is going to come knocking on your door because your parents are getting older and it's looking more and more like long-term care might be in their future, you're going to take the tiger by the tail and solve the problem. So you sue your siblings while there is no application of the Pennsylvania law in place. You sue them for support so that you basically get judgments against all the children, okay, that say we're responsible for the care so that you can enforce whatever the state of Pennsylvania might do in the future because of the judgment that you already have against them. You're not forbidden by the contribution and indemnity statute, which specifically related to Pennsylvania's application as a result of filial responsibility. Now you've got a whole set of litigation that has been created. I apologize. I have chosen this very unflattering picture of myself as penance because in recording the original video, I forgot about another aspect of the descent into misery. When Pennsylvania first began enforcing filial responsibility, it only chose to enforce it against children who were residents of the state of Pennsylvania. Soon, though, the state of Pennsylvania began enforcing the obligation of support against children who were not residents of the state of Pennsylvania. Those cases were, of course, challenged on constitutional grounds because, as it was argued, what constitutional right did the state of Pennsylvania have to interrupt the life of a child living in a completely different state to enforce their filial responsibility laws? Just so you know, those challenges were always ineffective, and constitutionally, the right of the state of Pennsylvania to enforce filial responsibility laws, even against children that lived in other states, was found to be constitutional. But again, this is a whole different level of litigation that occurred as a result of the enforcement and application of Pennsylvania's filial responsibility law. As a result of this descent into misery, the citizens of Pennsylvania were not happy. Planners were not happy. This experiment, which all started as a grand idea by the federal government, there have been multiple attempts to repeal Pennsylvania's filial support law, but they've all stalled in committee. They've never been able to get out without any action until recently. Recently, there was a bill introduced with unanimous support in the Pennsylvania House to change the filial responsibility law. The key change is that rather than an entire repeal of the law, which apparently has not met with any satisfaction in the legislature, the grounds for liability would become more narrow. Someone alleging a family member's liability for care would have to allege and prove that a family member either personally took or benefited from non-exempt transfers during the last 5 years, meaning that they've made improper transfers for Medicaid or for Medicaid purposes, or it was somebody who does not cooperate with the Human Services Department, a nursing facility, a provider, or other person in the medical assistance eligibility process. The first part of that, I don't think that anyone has any real problem. It really is that first tract of cases that I mentioned in the state of Pennsylvania where there was wrongdoing. In other words, a child either took advantage of or took advantage of the opportunity, either took advantage of a vulnerable senior or took advantage of power and authority over that vulnerable senior in order to transfer assets. The reason I say that there's a distinction there is because keep in mind, sometimes these transfers are at the request of or with the permission of the senior. The senior doesn't want these assets to be lost to his or her long-term care. So it's not simply as easy as saying that, well, the child took advantage of the senior. Sometimes the senior wants this. So, but that it would be considered a type of wrongdoing because if it was done within the 5 years prior to an application for Medicaid, that transfer is an improper transfer. And this would give the state the legal authority to go and collect those particular funds. Now, in other states, without filial responsibility laws or without other type of legislation that would allow the state to go collect those funds, the only thing the state can do is provide that the individual is not eligible for long-term care from Medicaid. And then that leaves the family the responsibility of figuring out what do we do? What do we do with a senior who needs long-term care, needs nursing home care, needs assisted living facility care, and there are no resources to provide for that care? What do we do? Well, ostensibly, what the state would assume is that the person who has removed those assets will return those assets in order to make those available to pay for the care. And in many cases, that's exactly what happens. Of course, there are situations where that can't happen because the money's been spent or it's been used or misused, and so those funds aren't available. But that's the first leg of the development of these cases, and that's also the first part of the new legislation is a person who has at least arguably committed a wrongdoing. But the second is the part that only demonstrates that the state of Pennsylvania may be furthering their descent into more misery. And that is that it holds a child responsible who does not cooperate with the Department of Medicaid, for example, a nursing facility, or a provider or other person in the medical assistance eligibility process. That means that even if a child is innocent, hasn't taken any money, but hasn't facilitated the process of an application for benefits through a Department of Medicaid or in human services in the state of Pennsylvania, that a child may have liability. Now, at first, that may seem, well, that doesn't sound like that's that big a deal. Well, let me give you some examples of what type of disputes have occurred in my practice between the Department of Medicaid and children that weren't wrongdoing, but could easily lead to allegations that a child is not facilitating, is not cooperating with the Department of Medicaid in the orderly application of for Medicaid benefits. The first example I'm going to discuss, and these are all true examples. I'm not going to mention any names, obviously, but the first example is a mother and a daughter. And the daughter, for most of her adult life, did not live with the mother, but the mother lived alone. Her husband had died at a very early age, and so she lived alone. And she was of fairly modest wealth, but she was living comfortably because she had a very good income. And one of the things that she loved to do is to gamble. She loved to go to casinos. She went to Pennsylvania. She was an Ohio resident, and she went to Pennsylvania to the casinos, and she would go to New York and to Atlantic City to the casinos on a fairly regular basis. Later in life, she took her daughter, and they would go on junkets. They would go and stay in Pennsylvania or they would stay in New York and they would gamble. The daughter wasn't as big a gambler and was not as devoted to gambling as her mother was, but the mother she did this regularly. It was something she lost a lot of money doing, but as the daughter explained, this is what my mom likes to do. And she wasn't ever putting herself in hardship. She had enough money. Everything seemed to be going well until she got sick. And she got sick very quickly and very quickly ended up in a situation where she needed long-term care. And of course, because her safety net was much thinner as a result of her gambling losses, it was also very necessary quickly to apply for Medicaid. Well, Medicaid looked at her finances for the previous 5 years, and they saw these transfers for gambling. And that caused them to start to investigate because they wanted to know that these monies that were paid for gambling weren't transfers to the broader family. The sister, in applying for the Medicaid application, disclosed to the state that these were gambling losses, and she knows that because she accompanied her mother on some of these gambling vacations. And don't you know that led to the next level of investigation? Now they wanted 5 years of financial records from the daughter. And they constantly were arguing that the daughter either took money or wasn't facilitating the clear explanation of what the mother's expenditures were for because the mother didn't have them. And so they were accusing the daughter. Well, what happened in that investigation is that they learned that, well, there were other instances in which the broader family had gone on vacations with their mother, and mother had paid for those vacations, and so they began investigating all of the children. And now through this, because this was a state of Ohio, and Ohio is not, even though we have a filial responsibility law in the state of Ohio does not use filial responsibility in the determination of eligibility for Medicaid in any way, shape, or form, ultimately was resolved. But it wasn't resolved quickly, and it didn't resolve without a huge amount of hardship. For example, one of the things that happened is that the Department of Medicaid originally provisionally provided for Medicaid payments, but it wasn't very long before they stopped payments because they felt that there was some wrongdoing that had taken place. That led to a problem because the nursing home wanted paid. Fortunately, it was resolved right before the nursing home had set a deadline by which, if they didn't have a determination of Medicaid that was favorable to them, they were going to basically evict or dump the mother out of the nursing home, leaving the family with that, all important problem. Well, what do we do now? What do we do if the state of Ohio is not going to pay for her assisted living or long-term care? Now, are we to use our assets, which we don't have a lot of, in order to pay for our mother? I thought that's what Medicaid was supposed to do. That just is one example where you can see that this family might very well have been in a situation where the state would extort from them, for want of a better word, payment for mother's care because of the inability of the family to answer a question which they simply couldn't answer, which is, what did mom do with all of her money? Because gambling a lot of times is cash transactions, and as a result, there was just no way to know where all that money went. The only thing the family could demonstrate with at least some level of satisfaction is that money didn't go into their bank accounts. Okay. Um, the second situation that I think that is a demonstration of how difficult this can be is when you have a situation that is more under the table and the children are not part and parcel of what the parent is doing. So the second example I'll give you is a father who had a number of, let's say, low quality rental properties in distressed areas. And as a result of which he was collecting rent primarily under the table, meaning that people weren't writing checks to him. He was getting cash. And some of that cash he would keep in cash. Some of that money would come into his bank account, but there was no obvious source for those because there wasn't rental agreements. There was no way to tie the income to a particular property because of the way that the father conducted business. Now, his son was his power of attorney for the last year of his cognitive life before he had to go into a nursing home. And of course, he is the person that, as far as the Department of Medicaid is concerned, is responsible for supporting an application for Medicaid. And although they had these properties, they didn't have income that they could rely upon. And so they applied for Medicaid, tried to evict all the tenants, and tried to sell all the properties. Of course, they were denied Medicaid until pending sale of those properties. That was hard to do, by the way, because these properties are not properties that a whole lot of people want. And so it was very, very difficult. The Department of Medicaid ran them through the ringer and would not approve the Medicaid application because of the lack of financial transparency of these transfers, of where these monies was coming from, where money went, why there wasn't more money in the estate. And of course, no one knows what happened to it. We don't know what father was doing it. And there is always the possibility, quite frankly, in that situation, that some of that money went to the kids. But there's no way to prove it, but you can understand how this might lead in the minds of the government not applying himself and not facilitating a proper application for Medicaid. And that's bad enough, but this isn't even sufficient for the law, because the law doesn't just limit it to cooperating with the government. It also includes cooperating with a nursing facility or a care provider or other person in the medical assistance eligibility process. Now, you know where my mind goes immediately when I think about the other person in the medical assistance eligibility process is one child holding another child responsible, saying, you haven't helped me in this process, so I'm going to try to make you responsible for whatever is necessary as a result of the Department of Medicaid not providing eligibility for Medicaid. So a child then is then back in the situation where they are a target, and you're going to see these types of claims made as a result of this legislation. The descent into misery started when a cost savings idea of the federal government was adopted by some states and implemented without due regard for what the implications are, either culturally or socially or financially, in the providing care for our seniors. It's very similar to the decisions that the federal government has made since the early 1980s, maybe the late 1970s, of truncating the type of care that you can be provided in a hospital. That's not a determination that's made on the basis of quality of care. The government didn't start kicking people out of the hospital because they had some grand vision that by moving you from a hospital to a nursing home and denying you Medicare benefits, that you would get a better quality care. There was no evidence of that. Hospital care was much more expensive than the lower expensive, and by the way, lower quality of care that a person gets in nursing homes or assisted living facilities. So the government incentivized the lower quality care in order to save money. It's the same type of decision making that one could arguably make is going to lead to the same type of results. So the answer to the question is that no, Pennsylvania is not repealing filial responsibility, and there's at least a good argument that its effort to resurrect what should be killed as an idea is going to continue, and probably to greater misery. Now, why you should be concerned about this is that some states have kept and retained their filial responsibility legislation, and some states, following the 1990 effort by the federal government to implement filial responsibility as a way to reduce the cost and expense of administering Medicaid and Medicare, adopted filial responsibility. The state of Ohio is a filial responsibility state, but we have our law, as it's currently implemented as more of, or what Professor Dickinson would call a welfare law, in that if you are a child who has an obligation to, because you've accepted a power of attorney or because you are the guardian of a parent and you do not do what you're supposed to, there's a consequence to that. But the state of Ohio has not employed the filial responsibility law in its application of Medicaid or its enforcement of Medicaid resource recovery. The state of Ohio has not gone that direction, but many states have these filial responsibility laws. To let you know how concerning it is that, with regard to whether states are going to carry the water of the federal government, there is only one state that looked forward, saw that this might not be a good thing, partially on the back of some of the experience that was already happening in the state of Pennsylvania, I'm sure. But the state of Idaho is the only state that I'm aware of that has actually repealed financial filial responsibility. As a person who has an estate plan, as a person who has a parent that you care for, you should be concerned about these filial responsibility laws and how they're going to affect you and your family. And so you should keep your eye on what happens to Pennsylvania. Pennsylvania may very well be the linchpin as to whether this is something that survives or doesn't survive. If this legislation, at least initially, looks good and seems to solve some of the problems of filial responsibility in that state, there may be other states that will take the bait. I hope you found this interesting. I hope you found the information here valuable. If you have any questions, don't hesitate to reach out to me. And of course, like, subscribe, and share this video. Hope you stay safe, be well, and God bless you.